In a century of Canadian womanhood, a royal commission has been established to examine the status of the Canadian woman.
I think we've gone about as far as we can go in accepting all this discrimination, in hoping that it might be changed, and nothing has come of it. And this is why our insistence of this group on a commission on the status of women.
Why a Royal Commission on the status of women? Don't women have a pretty good status in Canada?
The Royal Commission on the Status of Women was a real cornerstone for Canadian women to realize what their situation was and what they needed to do to change it.
Each woman must find her place, not be put in her place.
Women's rights.
That Indian woman has been the workhorse, the doormat, and the baby machine.
And God knows I'm not one of those fanatic feminists, but I mean, there are things that we have to recognize that are not what it should be.
When the hearings have been completed, and we have heard from the public, we will base our recommendations on the information we have received in these ways.
In the 1980s, the laws governing women and their bodies saw many controversial and momentous changes. To take a feminist legal perspective is to analyze works that are supposed to be gender neutral or objective. Feminist legal scholarship attempts to look at supposedly gender neutral laws and take into account women's perspectives and interests. The development of feminist legal scholarship began with the Royal Commission's report on the status of women. This report found many areas of law that needed to be re-evaluated to remove overt sexual inequality and discrimination, and remains a founding document in contemporary Canadian feminism. Some of the Royal Commission's findings were that the law contained gendered language that turned some offenses into status offenses. Women were seen as primarily the victims and not actors for certain offenses, and that overall the law did not provide adequate protection for all individuals. Sexual assault has been considered to be a gendered crime since 90% of victims are female, while 90% of the offenders are male. Canada's sexual assault laws were changed in 1983 with the introduction of Bill C-127. Prior to this, the criminal code contained offenses of rape and indecent assault. Non-consensual sexual acts prior to Bill C-127 were under the category of rape and defined as a male who has sexual intercourse with a female person who is not his wife without her consent. Under these provisions, a male could not be raped by a female, could not rape his wife, and penetration was required. Section 142 of the Criminal Code in 1970 also required corroboration of the victim's story, otherwise the judge was instructed to warn the jury of the dangers of finding the accused guilty based on just the victim's testimony. If rape was not reported immediately, it would also be considered invalid. The old laws also allowed questioning of the victim's sexual history in order to establish, and in most cases reduced, her credibility. These statutes demonstrate the sexism in society and in law, which reinforce the informal control of women and help to perpetuate the ideological premises of the traditional gender order. Dr. Tang of the University of North British Columbia has observed that the patriarchal basis of marriage was protected since husbands had unlimited and unrestricted sexual access to their wives. In this perspective, women were considered men's property. A woman's testimony was considered insignificant if there was no corroborating evidence, so therefore could not be trusted. It alone could not convict the defendant. Rape complaints that were not made immediately after the attack were invalidated. A woman's credibility depended on her sexual reputation and could be used to determine if she actually consented. Finally, women's sexuality was defined by men's sexuality, in that the requirement of vaginal penetration was the only standard with which a woman's body could be sexually violated in rape. Prior to Bill 127 and the sexual assault reforms, the Supreme Court of Canada handed down a decision regarding consent and the issue of mistake of fact in R.V. Papa John in 1980. Prior to Bill 127 and the sexual assault reforms, the Supreme Court of Canada handed down a decision regarding consent and the use of mistake of fact in R.V. Papa John in 1980. On August 14, 1976, the complainant, an adult real estate agent, and Mr. Papa John, a businessman looking to sell his property, were at a lunch meeting to discuss a real estate transaction. During this meeting, alcohol was consumed and the complainant went back to Papa John's house. Upon arrival at the house, the complainant asserts that she was sexually assaulted whilst protesting and struggling. The defendant asserts that there was merely coy objections, but had intercourse with her consent. The complainant phoned the police after she had run out of the house naked. During trial, the defense argued that the judge should instruct the jury to consider mistake of fact, that Papa John believed that the complainant had consented. The judge refused and the case was appealed to the Supreme Court. In Judge McIntyre's ruling, the issue of consent was examined as well as the defense of mistake of fact. McIntyre ruled that the defense of mistake of fact should be brought up as a defense only if there was corroborating evidence that would make a person believe that consent was given. Just because the defendant believed that consent was given is not enough to support the defense of mistake of fact. Bill C-127 was enacted in 1983 to protect the complainant from defending her reputation, to remove spousal immunity, and to de-emphasize the sexual nature of rape. The term rape was replaced with sexual assault, and gender-neutral terms were used. Section 272 of the new laws removed the non-marital requirement, allowed for female on female, female on male, and male on male sexual assault, and did not require penile penetration. Corroboration was no longer required, and the so-called rape shield provisions barred the defense from questioning a complainant's sexual history. The term sexual was used as a modifier to criminal assault. By itself, the term is vague and not defined specifically in the criminal code. This changed upon the Supreme Court ruling in R.V. Chase in 1987. On October 23, 1983, Mr. Chase was charged with entering the home of a 15-year-old girl. Chase seized the girl from behind and grabbed her breasts. Chase had attempted to touch the girl's private areas, but the girl fought him off. During the attack, Chase said, "You know you want it." Chase was charged and found guilty of sexual assault in provincial court. Upon appeal to the New Brunswick Court of Appeal, the verdict of guilty for common assault was substituted. The appellate judge found that the definition of sexual should refer to the genitalia. Since Chase did not touch the girl's genitalia, it could not be considered sexual. The courts noted that the new sexual assault provisions did not provide a definition of sexual. The Crown appealed to the Supreme Court. In the Supreme Court's ruling, Judge McIntyre found that sexual assault is committed when the circumstances are that of a sexual nature. The objective test to determine what comprises sexual comes down to, would a reasonable person determine that there is a sexual component to this assault? When considered in this context, sexual did not have to include genitalia or penetration and could encompass a wide variety of activity. The Supreme Court of Canada restored the original conviction, and the Chase ruling became the standard to define sexual.
And is joining with women all across Canada in a nationwide struggle to remove abortion from the criminal code and to make free abortions available to every woman on demand.
Women fighting together, working together is the only way that we're going to be able to change this law.
The abortion cavalcade left Vancouver with 5 cars filled with women who wanted to talk to other women and wanted to build the momentum across Canada. So we'd have women come forward telling us horrendous stories about their backroom abortions, and young women were being forced to have children they didn't want because of rapes, incest, the fact that they'd been sterilized without their knowing it or against their will.
We demand that women have the right to control their own bodies.
Abortion in Canada became decriminalized in 1969 with an amendment to the Criminal Code. Section 251 of the 1969 Criminal Code allowed abortions in cases where the pregnancy would or would likely endanger the life or health of the pregnant female. Additional subsections require that abortions could be carried out without penalty only after the approval of a therapeutic abortion committee that was comprised of 3 doctors. The doctors on these committees could not be the ones performing the actual procedure. Furthermore, the procedure had to be carried out in an accredited hospital. In addition, the Canadian Medical Association allowed therapeutic abortions in pregnancies up to 20 weeks in gestation. This time frame restriction is still currently in effect. The abortion law in Canada was seen as oppressive to women, and socialist feminists saw class as well as gender play a role in accessibility to this service. Not all women in Canada were able to access safe abortion, since not all hospitals had abortion committees or were licensed to perform the procedure. The Badgley Committee found that these rules in place did not allow equal access for women. The committee also found variations among physicians as to what constituted the definition of health. The definition of the World Health Organization was recognized by the Government of Canada and several provincial governments and the Canadian Medical Association. It stated, "Health is a state of complete physical, mental, and social well-being and not merely the absence of disease or infirmity." The committee also found that there were variations among what constituted consent for obtaining an abortion. Some provinces required that single female minors acquire the consent of their parents, while other provinces require the consent of the husband in addition to the woman's. Doctors Henry Morgentaler, Leslie Frank Smalling, and Robert Scott, all licensed and qualified medical practitioners, opened an abortion clinic in Toronto. The purpose of this clinic was to provide safe, medically supervised abortions for women who had not obtained a certificate from a therapeutic abortion committee of an accredited or approved hospital. This certificate was required by Section 251, subsection 4 of the Criminal Code. The 3 doctors involved in the case had been outspoken regarding what they felt were flaws in Canada's abortion laws. All 3 believed that women should have a complete control over the choice of carrying a fetus to term or terminating the pregnancy. Indictments were filed against the doctors, charging that they had conspired with each other with intent to procure abortions. At trial, the 3 doctors filed a motion that Section 251 of the Criminal Code violated Section 2, 7, and 12 of the Charter of Rights and Freedoms and was inconsistent with Section 1 of the Canadian Bill of Rights. The trial judge squashed the motion, and in front of a jury of their peers, 3 doctors were acquitted of the charges laid against them. The Crown appealed, the appellate court ordered a new trial, and the 3 doctors filed an appeal to the Supreme Court of Canada. The issue at hand was whether Section 251 of the Criminal Code of Canada, under which Dr. Morgenthau and the other 2 had been charged, violated a woman's right to abort an unwanted pregnancy without legal obstacles. It was argued before the court that the law was in violation of Section 2, 7, 12, 15, 27, and 28 of the Canadian Charter of Rights and Freedoms. The Supreme Court ruled that Section 251 violated Section 7 rights under the Charter and could not be saved under Section 1. The court produced 3 majority opinions and 1 dissenting opinion regarding the matter. As none of the opinions or concurrences received more than 2 signatures, none of them serve as binding precedents. The first majority opinion, written by Chief Justice Dixon, with Justice Lemur signing on, found that Section 251 forced some women to carry a fetus to term regardless of their desire to do so. It was argued that this violated the security of person guaranteed in Section 7. The delay in obtaining permission from the certification board also was found to violate this right, as it had the potential to put the mother at risk of physical or psychological harm. Dixon determined that the violation was not in accordance with the principles of fundamental justice, as women in areas with smaller hospitals that lacked a certification board may be unable to legally obtain an abortion at all, violating the principles of equality. Dixon found that the violation could not be justified under Section 1, as the aim of the law was disproportionate to the infringement on individual rights it caused. In the end, the law failed on every step of the proportionality test. He found the administrative process was often unfair and arbitrary. The resultant impairment of the women's rights was beyond what was necessary to evaluate their case. As a result, the effect of the impairment far outweighed the importance of the law's objective. Justice Wilson opines that it is probably impossible for a man to respond, even imaginatively, to such a dilemma, the one faced by pregnant women, because he can relate to it only by objectifying it, thereby eliminating the subjective elements of the female psyche which are at the heart of the dilemma. Another important case that occurred in the 1980s was Tremblay v. Daigle, which was a civil matter heard in 1989. Mrs. Daigle was seeking an abortion for Mr. Tremblay's baby. Tremblay sought an injunction to bar Mrs. Daigle from getting an abortion, and the courts granted this, and the injunction was upheld by the Quebec Court of Appeal. Mrs. Daigle appealed to the Supreme Court of Canada. However, by the time the Supreme Court of Canada heard the case, Mrs. Daigle had already gotten an abortion in the United States. The Supreme Court still felt that there were important issues to be addressed regarding the father's rights over a fetus and a woman's ability to obtain an abortion. The Supreme Court ruled that a father does not have a right to stop the abortion of a fetus, since his rights, as well as the fetus's rights, could not override the right of a woman. Prostitution has been an ongoing issue legally, socially, and morally, and has been in the legal spotlight since Canada's infancy. When considered from a social feminist point of view, there are gender and class factors that come into play. The resilience of prostitution throughout history and through various legal reforms has been said to occur because most legal reforms target women who are primarily the sellers and not men who are primarily the buyers. This is also a reflection of economic inequality in society. The earliest edition of Canada's Criminal Code, passed in 1892, defined prostitution as a common prostitute or night walker who is found in a public place and does not, when required, give a good account of herself. This law fell under the original vagrancy laws and legally only applied to women, making it a gendered statute. The Law Commission found that prostitution was a status offense and applied only to women, and men were only prosecuted if they were found in a bawdy house. In 1972, on recommendation from the Royal Commission on the Statute of Women, the vagrancy law was repealed and solicitation was substituted. Soliciting any person in a public place for the purposes of prostitution became illegal and applied to both sexes.
Well, there's certainly a consensus that prostitution is immoral.
The prostitute knows she's a prostitute. The police know she's a prostitute. She's out in the corner. They both know what she's doing. So it's kind of a cat and mouse game.
The government is finally willing to engage with the issues from a rational perspective instead of a moralistic perspective.
Prostitution has been called the world's oldest profession. Since the dawn of time, people have exchanged sexual favors for goods and services.
And the girl says what sexual act she'll provide for how much, or the boy. It's the same thing. We've got the same thing, male and female. So what you've got is that communication process is unlawful.
Next is the operation of a common body house.
Common body house is a place that's frequented usually, and typically the police need to prove probably 3 or more times, but it's a place that is frequented for the purpose of prostitution. So that would be like the old hooker house, so whorehouses from the saloon days sort of thing. That would be illegal. And as well, what you've got is, so the common body house though could be your apartment where you live, and if you take John's or Date's back there, then that becomes a common body house.
Finally, living off the avails of prostitution.
Bill C-127, passed in 1982, changed the definitions of prostitution once again. These legal reforms included a definition that defined prostitute as either sex and neutralized the gender in the procurement section. The Fraser Committee, commissioned by the Minister of Justice in 1983, found that prostitution was widespread and the main factor leading women into the trade was economic distress. The most significant finding, however, was the observation that Canadians opposed further criminalization of prostitution but considered it a nuisance and wanted it addressed. Armed with this insight, the Fraser Committee recommended that Canada regulate prostitution but not exclusively. The committee favored a hybrid model that included regulation, criminalization, and decriminalization. The committee also recommended that the government address and remove the causal factors that lead women into prostitution by ensuring adequate social programs and direct more funding to community groups. They also favored removing social inequalities between men and women. On December 28, 1985, Bill C-49 came into effect, which completely removed gender from both the buying and selling aspect of prostitution, and was meant to equally punish both men and women, or the sellers and the buyers. Bill C-49 attempted to address the nuisance aspect of prostitution and made it illegal to simply stop a vehicle, and formed the basis of our current communication law. Prostitution then, as now, is not illegal, but the act of communicating the intent is. In a review of the legislation in 1989, found that this law actually did nothing to curb street prostitution and was widely considered ineffective. The committee who conducted the review proposed, once again, implementation of social services to curb the need to enter the field, harsher penalties for repeat offenders, and mandatory minimum sentences. The government rejected all these recommendations.
Royal Commission on the Status of Women include abortions on demand and more daycare.
Sounds sort of revolutionary, but on the other hand, what are we here for?
We mustn't look down on the woman who needs daycare services to leave her children there when she goes to work.
A new study puts Canada last when it comes to the quality of early childcare.
Childcare is the key that will open the door to future equality.
It was all forms. It was financial, it was sexual, it was physical, it was emotional. I'm angry, but you know what? I have a right to be angry.
It's not safe anywhere for Indigenous women.
Challenging the existing culture of violence through education.
Like funding, space, access. Our freedom and safety as women is possible, and we won't be told otherwise or settle for anything less.
We demand that women have the right to control their own bodies.
No matter what other arguments we put forward, the root cause is selfishness and sin.
Rights that have been hard-won could be easily diminished.
Some of us are brand spanking new to feminism.
We saw we could make change, and we need to do it again.
You just say, ready or not, here we come. Thank you very much.